Gentlemen, we'll get started here. If this committee can come to order. Good afternoon, members of the committee, ladies and gentlemen, members of the public. We've got a full house here. Looks like, I'm sorry there's not enough seats. Looks like there's a significant amount of interest in House Bill 51. So let me give you just a little bit of a logistical outline of what we're going to do here today. We're going to hear House Bill 51, and then at the conclusion, I'll accept a motion, and we'll take a vote. What I'm going to do is I'll present the bill, since it is we have several co-sponsors on that. Representative Quick and I and others have worked on this piece of legislation, but since it was originally under my signatory, I'll present the bill, and then at that point, I'll take questions from members of the committee on the proposed legislation, and only members of the committee on the proposed legislation. And then we'll go into the public comment portion of this. This is a large room. A lot of people are standing. I've spoken with the advocates for and against, and we're going to take testimony from 4 individuals, 4 for and 4 against. And they've each given me a list of who will be speaking in for and against, and then we'll talk among ourselves as members of the committees, and then I'll look for a motion. We can after we hear the testimony. Any questions by members of the committee? Okay, thank you for attending this. This is House Bill 51. Ladies and gentlemen, House Bill 51 is, in members of the committee most particularly, this is a continuation of the conversation we had last year with the Georgia Institute of Technology, most particularly. I will commend them. Their process has come a long way from when we had Mr. Peter Burkett sitting in that chair. We all heard the stories. We all heard the concerns, and the Regents system and this House of Representatives has been working diligently. A lot of time and effort went into trying to make some significant changes, and some changes were made, most particularly at that institution. But ladies and gentlemen, my file continues to fill up with very concerning abuses of the basic right of due process for citizens of this state. It is patently obvious to me, and I've had these discussions with the Board of Regents themselves with respect to the resources that can be allocated to a campus investigatory and adjudicatory process in Title IX cases. It's very obvious that campuses need to be in the business of education, not in the business of the civil authorities and punishing those who break the law with respect to sexual assault. There's not enough money, time, training, or effort that can be spent on our university campuses to make those campuses safe or to bring to justice those who commit these significantly vile acts on campus. So House Bill 51 is a change in policy for the state of Georgia with respect to Title IX. House Bill 51 is going to, in effect, change the rules. There will not be separate and individual Title IX investigations on campuses. All felonies will be treated the same. A violent assault on a campus, whether with a baseball bat or sexual assault or murder or any of those, is a serious, serious issue. And we spend hundreds of millions of dollars in this state. And you'll hear from law enforcement, and you'll hear from the prosecuting attorneys here today. These people are trained. They have one real goal, and that's to keep our citizenry safe from those who would prey on them. We in Cobb County have probably one of the top special victims unit in the state. The assistant district attorneys she runs that. She's tenacious and ferocious, and she puts the bad guys away and does a really good job of it. We have extremely well-trained investigators, police officers and police detectives who have dedicated their entire career to understanding the special victims in these kind of cases. We have jurists that have been trained their entire careers as judges to hear these cases, and they understand due process. Members of the committee, due process is not the basis for these campus tribunals. Just anecdotally, guys, when Earl Earhart and the Harvard law faculty, who are 180 degrees on most philosophical propositions, agree with respect to due process protections, then you know there's something that is at the basic bedrock of our jurisprudence or our systems is off kilter on our campuses. We have functioned under interestingly enough, the juxtaposition of the former bill that was in this committee and the previous committee of a federal government who, not through law, not through regulation, but since 2011 has threatened federal fundings to states and universities with a guidance letter that said, and created a consequence. If you did not follow this particular guidance with respect to a separate set of processes, certainly not your basic due process, right to counsel, right to confront witnesses, right to a standard of evidence that is clearly realistic with respect to the offense, and there are lawsuits against that. I would submit that those guidance letters are coming to an end. That may or may not be the case. I have pretty good information that that's not going to be the case. So the federal stick is not hanging over our head. So this piece of legislation is there to protect the citizens of the state of Georgia, to create a safe campus. And to those who are survivors of these types of things, I make a clear statement that we're going to provide the resources for safe campuses. We're going to provide the resources for the counseling provisions. And we're going to provide an aggressive and unrelenting law enforcement resource to lock up those who commit such acts. But what we're not going to provide is a separate set of due process or a separate avenue for justice in this country. So let me tell you what, we'll walk through this. This applies to both the public and the private universities in this state. This legislation creates a duty to report on our campuses. But there has been a misperception. This statute, my intention is never, ever, and it does not say such in this legislation. It says very clearly that a victim does not have to go to law enforcement. That is a choice that the victim can make on their own, with their own conscience. There'll be resources. You'll see language in the budget, if I'm successful, that reallocates these Title IX offices' budgets to, again, counseling, prevention resources on campus. So this bill allows a victim to go to the privileged communication individuals, and we've got a long history. You'll see on line 53, 24-5-501 is a list of those who can take privileged communications. That's licensed social workers. That's psychiatrists. There's an entire list of those. Every university in the state has those resources. If they don't, we'll provide the resources for them for that. But I can tell you, I've already asked the question. They have these resources. But what you can't do is you can't create a liability for the state. If you report, you can choose not to report to the police. You can choose to report to a privileged communication. But you can't report to the university police a crime without an expectation that they're going to have to do their diligence to investigate that crime, nor to any other agent of the state. You can't create that liability on the taxpayers on the state. So that's the differential. You can make that choice on your own with your own conscience. So that's one thing it does. It takes away the separate investigatory single investigator model that does not grant due process in that state. We've heard that testimony. That's a fairly simple piece. In Section D, it clearly states This code section shall not supersede federal statutes or properly promulgated federal regulations to the contrary. But it shall, and it makes it real clear, it shall supersede in the case of federal guidance letters and other expressions of opinion regarding federal policies by federal agencies. Lord help us if we ever get to the position where we accept that unelected administrative personnel at any level in any federal agency get to make the laws that govern our lives. I really want somebody to tell me that that's a good idea across the board, because in this country we have these equal protection concepts. So you can't have a special set of circumstances. The ends can't justify the means in our system of laws. It does that. And ladies and gentlemen, it's going to change some of the abuses on these campuses. We're going to hear testimony from a survivor on the other side of the equation, a family. We heard a lot of those in the last committee that we had. Members of the committee, we heard where exculpatory evidence was not heard. We heard where an allegation effectively equals a conviction. And you'll hear that this is not a legal proceeding on a college campus. Well, it might as well be. The Supreme Court has said if you take away an individual's college education, that's a taking. Your family generally saves their entire life to spend everything they have for a college education, $20, $30, $80, $300,000, depending on the schools. That's a lot of pain and effort for a family to get there. And I don't want the state of Georgia to put somebody at risk without a significant due process protection, if that's going to be the outcome, because that's what's happened. These individuals have lost their entire college education. Some of the testimony we heard last year, they're in the final semester, and it was ripped away. And their professional careers are in tatters because they'll never get a professional license, and they'll have the scarlet letter of a sexual assaulter. If we're going to do these kind of things, then there's got to be a basic due process. Let me tell you, it's not going to be my child that's not given the resources to do that against the state. I'll afford legal representation for my child. Look at the representation the disadvantaged youth has. How are they going to stand up? The family that doesn't have the resources, the football player that may be there, that's their scholarship. What are they going to do? How are they going to fight the power of the university legal department and a Title IX bureaucracy? And how are they going to defend themselves? Read To Kill a Mockingbird if you want to know who gets the short end of the stick when due process is not the law of the land. That's what we're talking about. We're not talking about a situation where we're going to create a situation where this is not a serious issue. It is a serious issue. We're going to provide the resources to truly make sure that the bad people who commit these crimes are not a part of our system, and they'll be brought to justice. Members of the committee, I'm sorry for the longer dissertation, but this is a passionate issue. I've sat with the last destroyed family, the last young man who committed suicide, or almost committed suicide. His mom got home just in time to save him. Consequently, a year and a half later and $26,000 worth of attorney's fees, he's been found innocent. The parents were school teachers. They don't have that money to that education's gone. I mean, what are they going to use to pay for it? The state's not going to make them whole. And that's not right. So through this legislation, I'm asking us to act. And with that, members of the committee, I'll take questions, and then we'll take public comment. What number are you, Representative Chairman? Who was first? Representative Chairman Gulick.
Thank you, Mr. Chairman. No, this is
No, I'm sorry. It should be on. You're
okay. Yeah, it is. Thank you, Mr. Chairman. Just a quick question, and looking at the substitute LC 288277S.
correct.
And this is an issue that came to me in some discussions with advocates on the issue and our friends from the YWCA, actually. And the concern was, and I think it was a valid concern, about the practical considerations of if an incident occurs, will the university have the ability, separate and apart from disciplinary proceedings, to take what I would call administrative actions or measures, whatever you want to call that, to, as a practical matter, contain the situation and deal with the situation. I'll give you a perfect, I don't know if it's a perfect example, but a practical example. You have a situation where, something occurs between two students. It could be a fist fight. It could be someone allegedly stole something. It could be an assault. It could be worse. They're juniors or seniors, and it occurs at night, and they're in a seminar the next day at 10 o'clock tomorrow, or 10 o'clock the next day, and they're in the same class, same seminar. The university, the concern was that in a situation like that, or if they're in the same dorm floor, or whatever, something like that, the concern that they had, and frankly I shared as well, is that that the university would potentially not have the ability to take actions, common sense measures, in order to address that for the purposes of keeping the peace, so to speak. The way I read it on line 37 in the sub is that the post-secondary institution may pursue interim measures, comma, as well as formal disciplinary actions, comma, et cetera. The way I read may pursue interim measures is that provides the avenue for university administration to take those practical steps, those practical measures in those what I'll call real-life situations. I think you've had some I have not had a conversation with the university system. I think the chair has. And I don't want you to necessarily speak for the university system, but if the university system can address that very quickly and just tell us, yes, that's enough, that language provides then the latitude to go ahead and take those practical measures post-situation, I think that'd certainly be helpful.
Chairman Golick, I'm sorry, I did not mention that. That was a part of what I should have gone over. That's a very clear concern, and as a matter of fact, I spent 45 minutes with the university system on that just yesterday. That's why there's one change to the substitute that I'd passed out. I did before this meeting let some of the advocates know on the against side that was the change we made to specifically address that. And I believe the representative of the university system is here. We actually changed that with an eye toward making sure that interim measures such as temporary removal from classrooms, from dormitory spaces, the things that are done currently with respect to any other felony or assault on campus. Sam Birch is the Regent's attorney. Is that a clear characterization of the basis? And does that answer Representative Golick's question that university has that capacity under this language?
Yes, sir. No. It does. It gives us the real measures.
Okay.
Thank you for that question.
Thank you.
Thank you, Sam. The change, yes, in 8277S. Prior to that, it wasn't as clear, and we wanted to make that clear. Okay, Chairman Sessler. Yours is 3.
Yes, sir. Thank you, Chairman Earhart. As we approach this, I wanted to share this both with the chair and also with the folks that came today. I was approached by some people on this bill and talked in some detail a couple days ago, and I wanted to highlight just a couple things, if I could, Mr. Chairman,
Please do, Chairman.
At this point. When folks asked me about where I was on the bill, in fact, they're here today. Appreciate them coming. I asked that this be considered as a serious legal matter. And my approach to this, Mr. Chairman, is as a serious legal issue, not one in which I sort of bring a predetermined opinion to that I'm trying to score points for this side or that side. I'm not there. It's not where I am. I think members of the committee are not there, and I would encourage members of the public that came today to not pre-decide the words on the page that this committee or this legislature would act on. Because what this committee and I think this legislature is committed to is justice and right policy. And we talk about that. We think about 14th Amendment equal protections. When you look at this from both sides and you see it in full view from both sides of this perspective, these are very important issues for for folks on both sides of this divide. So if you came today in support of this, I would ask that you think about what the arguments may be to refine this to make it better, to make good law. If you came today opposed to this, I would ask you to look at the details of this and let's make good law. Because I think that's what we're about. And the things, Mr. Chairman, I'll share with you. I will share some concerns later at the appropriate time if it's the pleasure of the chair for me to be able to do that. But rules of evidence, making sure that hearsay evidence isn't able to be introduced into these hearings, that we have a disciplined process. We have those rules for a reason in civil proceedings and in criminal proceedings. That there be a very clear standard. If someone's going to be expelled from school for something they did, that there be clarity on that and not be a 51-49 decision, okay, you're expelled. We're 51% sure you should go, so you're expelled from college. There needs to be clear, convincing sort of a settlement among the panel that that's what that someone's guilty before they're expelled from school or serious administrative remedies are brought. And then finally, Mr. Chairman, I would say, as we consider this, people tend to talk about criminal proceedings and civil proceedings. This is just sort of an administrative proceeding, and they somehow think it's less important in people's lives. But Mr. Chairman, I would share with you and members of the public today that if you think about standing before a criminal court and facing 14 days in jail, to serve in jail, and 6 months with a probation officer, versus being expelled from school after 3 years of your time in university and being gone from the university system forever and getting no college degree. If we were faced with that devastating choice, what's the more severe penalty? What hangs in the balance? What is more hanging in the balance of doing 14 days in jail and seeing a probation officer for 6 months, which is a criminal case, or being expelled from college? And I say that, Mr. Chairman, just in wrapping up, because being expelled from college, I would argue that there's more hanging in the balance there, which highlights for us the seriousness of these proceedings and us to treat them on equal standing with criminal proceedings in ways that I'm afraid may not exist today. And that's how I'm approaching this today, Mr. Chairman.
Okay. Thank you, Mr. Chairman Sessler, for your comments. Okay, I don't see any other questions from members of the committee, so we'll move into the public comments. Oh, I'm sorry. Dean of the House, what's your number? There you go.
That's it.
Former rules chairman.
Yeah, used to meet
I'm a former too, so I can say that.
We're used to birds. Used to birds don't make no soup. But we're here,
Yes.
Mr. Chairman. I just had three areas, and I was with you last year when
Yes,
we
sir.
had the hearings and dealing with sexual assaults on our campuses, and had an opportunity to hear from the university system and from the public as it relates to where we are today and what's before us now. On page 2, on the interim measures, and I know the Board of Regents mentioned that. Could somebody drill a little bit on me for that, the interim measure? Because is it possible to have temporary, non-disciplinarian type actions that can be expressed or applied to, and because that interim measures, it's throwing me off a little bit, because if we had something that was temporary from a non-disciplinarian perspective as it relates to the circumstances surrounding the alleged assault, I just think that would clear me up a little bit. Is there any way,
Mr. Chairman, if Sam or if you want to respond to that, yes, go ahead.
Doing interim measures might be something like changing students from one class to another class, not discipline, but doing things to separate parties. We sometimes need to do, as you stated, common sense measures so that people can coexist while we're trying to figure out what happened, if there is any wrongdoing or what have you, but just to separate the parties. Maybe it's a residence hall situation, not taking disciplinary action, but separating the parties. And we feel like we really need to have the latitude to do that type of thing.
Well, tell me what's temporary non-disciplinarian actions.
If we're disciplinary would be if we say you're removed from housing.
I see.
We wouldn't say you're removed from housing if it was a non-disciplinary matter. They say that we are changing housing, they said, we wouldn't say you're removed from a classroom or from a particular course. We may change the course time or something of that nature so that people can continue their educational studies, but not face any disciplinary consequences.
Okay, thank you.
Representative Smiley, this is Kimberly Ballard Washington.
Yeah,
She's
I
one of
know.
the legal
Yeah, I
for
know.
the edification of
Yeah.
the rest of the committee, she is one of the regents' councils, specifically in this area.
Very good person.
I would agree.
Mr. Chairman, then under the part 3, and I appreciate
which line?
on line 23. Well, yeah, line 23, dealing with under the laws of this state. Would you be amendable to under existing state or federal laws?
Representative Smiley, I think what we've done is, under the laws of the state, what I'm getting to in line 23 is that I want to make sure that it's the privileged communication. Is there a federal statute that is specific? Because that's referring to, if you look at line 53,
Yeah.
24 is the privileged communication. If there are more privileged communications in a federal statute,
Yeah.
I'd be willing to work with you on that. Once we sit down and look through that statute, I'm very amenable to that if there's something else.
And that's what I was leading going to, because there's some correlation between that section and dealing with back on page 2 when it deals with the federal statutes and the rules that are promulgated. It says that, but shall supersede in the case of federal guideline letters and other expression of opinion regarding policies by federal statutes. To me, those two are kind of related, because look like to me what we're trying to say is that that the code section shall supersede federal statutes as promulgated by federal regulation, but we're not going to deal with the guidance letters and things of that nature.
Representative Smiley, you know me pretty well. I'm pretty plain on those kind of things. That's correct. It's saying specifically we're not going to deal with the guidance letters. We're going to not take those as a statute. If there was a regulation, then that's federal law for all intents and purposes. But we're going to not take into account the guidance letters.
So to make
dear colleague.
So to make it clear, if it's a federal rule and promulgated, then we're in the scope of it.
We have to comply.
But if it's some sort of an opinion or federal guide letter or something that somebody has written,
Correct.
then we're not under the auspices of it.
We're not under any obligation to follow it. Yes, sir. Do you have any further questions?
No.
Okay, thank you. Chairman Knight. Hold on. Technology. There
Dean
you
of the
go.
House, I want to make sure I'm clear on this, but isn't line 23 it's dealing with employees who have privilege, subject to privileged communications, and I want to make sure that I'm understanding. And of course, Dean of the House, very well. He's been here a long time. I want to respect where he's going with this, but that's dealing with a different section as to other than privileged employees who may have privileged communication rights, right? There's a difference.
Right. I think we came to an agreement that what I was getting at is no guidance letters, but that privileged communications. If there are federally privileged communication individuals that we might not have, and even those individuals have certain duties under their own statutes with respect to serious crimes and that kind of thing, that a psychiatrist may have a duty to report, but that's a different law. All I'm saying is those individuals can hear that. If there's a federal one, Representative Meyer, I'll be glad to talk to you about it, and we might need to add it, but I don't think there is, but I don't think there's any.
But back to
Sorry.
what I was trying to
You're back on.
offer up is where, and I agree with you, Representative, that is a different aspect of the law, but I was trying to just bring in federal law where it says state law. I was just thinking about under where it says information provided to an employee privilege under the laws of this state, which would, and I was just saying under information provided to an employee privileged under existing state or federal law. So what I was doing was just adding federal law to it.
All right. I want to make sure I'm clear.
I agree with you, Representative.
Let's keep
Knight.
having that conversation.
Yeah, okay.
All right. Any other members of the committee with a question? Nobody's, push your button if you do have a question, because none of these lights are lit. So, anybody? All right, now we'll move into the public comment section. Let me make sure that I've got the public witnesses here. What I'm going to suggest that we do is we'll start, since I made the original presentation for, we'll start with against right now. Advocates against, I have Ms. Grace Starling. I have Mr. Matthew Wolfson. Are you all here? Okay, I'm just making sure you're here so that we can move right through. Miss Jessica Caldas, okay, and Miss Helen Robinson or Robin. No, I'm sorry for the mispronunciation. It's not Robinson, okay, and she is here. Okay, just okay. I'm sorry. This handwriting is okay. All right. Those advocating for the legislation will be Mr. Jonathan Hawkins, Esquire. Mr. Hawkins, you're here. Mrs. Hinchy, you're here. Sheriff Barry and Representative Regina Quick will come together. And Mr. Danny Porter, the Gwinnett District Attorney. Danny, are you here? He's in a Senate committee hearing. Sometimes the senators, they take a little bit longer to get to things, but I think we'll hear from Danny last if he does get here. So, and if he doesn't, it'll be for. We'll ask if there's anybody else that wants to speak for. If not, we'll just deal with what we got. So what I'd like to ask is let's try to keep these around, I think I told you this, around five minutes or so, and then we'll have interaction with the members of the committee. So Ms. Starling, if you will come to that microphone right there. Is there a chair there? Good. Okay. Miss Grace Starling. Let me turn the microphone on.
Thank you. Okay.
Please proceed.
Good afternoon. I would like to thank the committee for allowing me the opportunity to come to the table and share my thoughts with you about House Bill 51. My name is Grace Starling, and I'm a survivor of sexual assault. But honestly, I'm more than that. I'm a daughter, I'm a sister, I'm a friend, and I'm a law student. And I'm a fighter. And that's why I chose to report my assault. I was 19 years old when I was raped. It was over a long weekend, and we had Monday off. I remember when I first saw my stomach the next day. And then my legs. Rug burns and bruises. And for the next 2 days, I didn't do much of anything besides cry myself to sleep. At 8:30 a.m. on Tuesday, I had contemporary art and theory, and I had a presentation due. My presentation was subpar at best, and I'm a good student. I remember the utter disappointment I felt. Immediately after class, I found myself sitting in my professor's office sobbing. She asked me what was wrong, and I blurted out, "This weekend, I was raped, and I don't know what to do." I did not first go to a therapist or a certified licensed social worker. I did not go to a physician or a psychologist. I went to a professor because I'm a student and I was worried about my grades. Now, before I go further, I want to draw attention to the fact that if this bill had been law 3 years ago, this would have effectively been the end of my power to decide anything for myself. I would have been forced to do something I wasn't prepared to do, go to the police. While I ultimately decided to report my assault, and I reported it a day later, I can assure you that if I was not able to decide this for myself, I would not be sitting in front of you right now. I don't know if any of you have ever gone through a criminal investigation for rape. If you have, I'm so sorry. And I'm sorry because it's not easy. For me, it was 2.5 years of grueling interrogations, probing questions, blame, and waiting. And waiting. I fielded calls from lawyers, ADAs, investigators for 2.5 years. I had already graduated college by the time and begun law school by the time the criminal investigation concluded. So I want to say this again. If this bill were law when I was raped, I, as someone who chose to report my own rape, would not be sitting in front of you right now. If I was forced to go through the criminal process, I would not be here. And I do not believe I could have gone through the investigation if it were thrust upon me without my say-so. I could not have done it, and I wouldn't have. And I'm concerned. I'm concerned as a survivor and a student. And I'm concerned that as well-intentioned as this bill may be, it has some very real and uninhibited consequences that would silence victims and immediately expose both parties to volatile situations. According to the revised bill, the school can take disciplinary action once there is a hearing affording due process to the accused student. And this is not where my issues lie. My concern is that if the administration receives information excluding from privileged employees, which would lead it to believe that a crime had been committed by a student or on campus, they have a legal obligation to report to the felony to the police. And this hearing would only come about once the victim came forward to the administration, who would have a legal obligation under House Bill 51. There are only so many options for the victim here. Keep quiet and only tell the people that the law permits you to tell, or you tell who you want, and you face a grueling and re-traumatizing experience in criminal investigation. If you pass this bill, you will take away our voice. You will take away our ability to regain control of our lives. And we know this isn't what you want. I remember the moment I decided to report. The police officer was sitting across the table from me, and he placed the recorder on the table and said, "Before we start, just know that once you start this, you cannot go back." I sat back for a second, and I thought about how scared I was, how I hadn't told my mom or my dad or my friends, but I thought about my professor. I thought about how she encouraged me to report my rape, not because she had to under state law, but because she thought I was strong enough to handle it. And for the first time since that night, I was in control of what was about to happen to me. I was in control. So I leaned forward and I told him I was ready, and he pressed record. 3 years and some odd days later, I have a petition with over 1,300 people's signatures against this bill. Students gathered these signatures in a week, and we're growing in numbers. We have the support of students and parents from every single possible district. We believe this bill shouldn't be political, and it shouldn't be reactionary. And many of the representatives have very real concerns about people being kicked out of school for things that they didn't do, and being kicked out, and how innocent boys are being kicked out of school for rape. And we hear you. We don't want this to happen either. We don't want innocent people to be punished. And we recognize as students that the administrative process is far from perfect. But the answer to this is not a reactionary and charged bill. This bill claims to help both parties, but it helps neither. It immediately exposes the accused student to years of traumatic criminal investigation that an improved administrative process would not do. This bill will not protect us, victim or accused. A school's job, as we have talked about, and its duty of care is to provide equal access to education to each and every student. If victims have to attend class, live in dorms, and study in the same spaces as our rapists, if we choose not to report and trigger the hearing, we will drop out, fail out, or transfer to less reputable schools as our grades plummet. This is extremely dangerous for our mental health and physical health, as well as our well-being, as well as a major deterrent to completing our education. Unless we want to automatically report to the police, we will see our rapists every day, and we won't be able to tell anyone besides a therapist, licensed clinical social worker, or other health professional about it. And this is not right. And if you think we're using fear to convey our message, we want you to know that's because we're scared. We're scared about this legislation on our campus. And we as students will not stand for mandatory reporting on our campuses to trigger disciplinary hearings. If this bill is meant to protect us, then listen to us, because we do not want this. I am asking you to consider carefully how you choose to interact with this bill. A victim who instinctively turns to her professor for help should not then be stripped of her ability to decide what her next steps are. And every single victim should have that moment to decide whether or not they want the police to hit record. Thank you, and I look forward to your questions.
Thank you. Any questions from members of the committee? Thank you, Ms. Tarling.
Thank you.
Thank you.
I appreciate it.
Okay. On the for advocacy side, I think we have Mrs. Hinchy here. You want to ask me a question, sir? No. Ms. Starling, would you like to come back? Chairman Setzler has a question. Pass these out. That's your next.
Yes, I enjoyed our conversation on Monday.
Spoke the other
Thank
day.
you.
Appreciate your passionate presentation. What would you propose the process be that would, and I want to hear a little bit more from you, and it was very organized how you laid it out, but I'm not sure exactly what you're advocating
Policy-wise.
the policy ought to be, and why that policy would have a real material difference in people wanting to come forward and share, and how that would play out in a significantly different way than what's proposed.
Right. So my main issue with this can be found between lines 39 through 46, where the only way to have these interim disciplinary actions would be to go to administration, which would trigger the police reporting, right? So to allow a student to be removed from a class or change a dorm room, you would still have to go through mandatory reporting. So while it does allow schools a little bit more leeway in being able to discipline, I guess, I mean, the school's job is not to discipline, it's to have equal access to education for both parties and protect students as a duty of care, as Chairman Earhart said. So I think if we could in some way not tie that safety and that interim protections that are necessary for both students, and I think when we spoke, I used the example of if there's a violent rape committed and you go to the police and you're being pulled in and out of class, right? So like when I reported, I was driving to the police station, I was driving back, I was going to art history, I was going to my econ class, I was constantly moving back and forth, taking calls between classes. Your rapist is doing the same thing. The accused student is doing the same thing, right? So you're being put back in situations where it's not healthy, it's not good, it's volatile.
Sure. So I guess what I'm trying to parse, Mr. Chairman, with Ms. Starling is the question of interim discipline and interim non-disciplinary things. What we heard one of the region's attorneys speak to, and this is what I'm trying to kind of maybe divide the question here. So what you're advocating is that interim non-disciplinary actions, putting them in a different class, perhaps
should not be tied to mandatory reporting.
Maybe have them move into another dorm if there's some hullabaloo about a possible circumstance. That's something you want to see happen. Would you recognize that interim disciplinary actions, which means expulsion and removal, would you recognize in that subset of cases where they are moving towards something that has a kind of a permanent impact, not something that's just moving kids around so they're separate while we sort this out, but would you acknowledge that the interim disciplinary actions should have more due process and should be subject to a more rigorous level of scrutiny?
I would never advocate for any haphazardous way of attaching being suspended or expelled to a student, right? I completely agree with that.
Okay.
I just don't think this bill is the answer.
Well, I hear that,
Yeah.
but what we're charged to do is maybe perhaps divide the question. What I'm listening for carefully is if the concern is that while this is happening, the two parties perhaps need to be separated. It's not contemplated as the bill in the four corners of the bill now, but if that's the issue, for non-disciplinary actions that are interim, but what I'm hearing you really argue for is you got to separate people, but that you recognize that if before the criminal case is adjudicated or a civil case is brought, before that's all adjudicated, if the administration is moving through a process of expelling someone from school or disciplining them in very serious and kind of final ways administratively, you agree that needs to follow a rigorous process, but you're really talking about something different than that.
Well, I agree with that, but I also don't think that the criminal procedures have a hand in school disciplinary actions. I don't think that a police officer would be within their scope of employment to say, I recommend that you suspend or expel this person. And I think it's conflating the two. And I think it's conflating the school's responsibility and the criminal justice's responsibility, which is to attach stigma, right, of a criminal. Schools may attach stigma of someone being expelled. And I know you have expressed your opinion that it is more detrimental to be expelled from school. And I understand that, and I see that, but I think the way this bill is conflating the two is not providing the victim enough options to fully be separated. Because you can say separated by classrooms or dorms, but at the end of the day, is that ever going to be enough?
Sure. And I asked the question because there's not not to be curt, there's not this bill. I mean, this bill is words on a page that's working itself through the legislative process. It's not a matter of polarize and mobilize. It's a matter of working through and
Right.
crafting something that works. And again, you talk about conflating two distinctly different ideas, but I think what I'm hearing you say is that you recognize that expelling somebody from school should take a very rigorous due process, but that the idea, the things short of that are practical, that are doable, that are contemplated by the Board of Regents that happen every day. Let's reassign them to a different economics class. Let's put them in a different dorm. Let's separate these kids. Maybe have a hearing that says you guys don't need to be within 200 feet of each other. Whatever that looks like. There's something something short of these interim disciplinary measures. That's really where I hear you saying your concern is in a practical basis of how this plays out.
That and that it would be tied to mandatory reporting. So the only way to access those different would be through mandatory reporting.
Okay, so for these interim non-disciplinary measures,
Well, as the bill is written now, those are still have to be accessed through, right?
Yes, ma'am. Thank you. And what I think you're adding to the committee here is maybe dividing this question, as you said.
Yes.
That if there's a request to separate people and have these interim non-disciplinary measures, which separate people and kind of keep parties apart while this plays out, that shouldn't trigger mandatory reporting. Correct?
Right.
But if there were a circumstance where somebody was before a tribunal considering expulsion from school, that's consistent with a civil action. That's consistent with a criminal prosecution, perhaps, and that rises to a very different level from what I'm hearing you say.
I think if the case is egregious enough, it should still not trigger mandatory reporting if that would be the adequate way to provide equal protection to both student and accused.
I don't understand what you're saying.
So if the way to provide access to education to the victim and the evidence is egregious enough and you have the burden of proof that, as now it's preponderance of evidence, I understand the argument for clear and convincing, but for now, the preponderance of evidence, if it is enough that is what is required to protect the student that is enrolled in your university, they should be able to take that action without having to report without a victim's consent.
For
Disciplinary actions.
For non-disciplinary actions or for disciplinary actions?
For both. I mean, I think that the school needs to have a scope that they can choose from.
Okay. So
And I'm not saying that school administration is perfect at all. There's a lot of work that needs to be done. There really is. But I think that it's not being adequately addressed right now. And I know you said, the four corners of the page and it extends past that. I think this is one of the unintended consequences of the four corners of this page that extends off.
Mr. Chairman, I raised this because as the committee wrestles with this, I heard an emphatic sort of support for creating conditions that allow people to share things with people, to talk about things that happened that in a very human way that people need to be able to do, that doesn't trigger some runaway legal process you can never draw back in.
Right.
But I think what maybe I'm challenged to think about is if you're pursuing an action, if the university is in essence playing court. I mean, you think about criminal cases, civil cases, and these life-changing administrative disciplinary cases that really have a court level of impact in someone's life. I think you would agree that there needs to be a due process, sort of an evidence standard,
I would
a
agree
clear
with
and
that
convincing sort of
completely.
standard for those.
Well, I would agree that there needs to be absolutely a qualified and capable system in place. But I don't think that the only answer to that is mandatory reporting.
Okay, thank you.
Thank you.
Understood.
Okay, no further questions. Okay, Mrs. Hinchy. Thank you for coming. You have her testimony also written here. And just for information for the public, anybody that wants to submit written testimony to the committee, I'll make sure that's disseminated outside of those who are speaking as well. Go ahead.
Representative Earhart, members of the committee, ladies and gentlemen, thank you for your service to our community and thank you for having me here today. I want to share my family's story and to speak to something I have grown to feel very passionate about, due process rights for the accused. January 11th, 2015 will always be a day of infamy for our family. It was the day that we found out that our son, now a senior at Georgia Institute of Technology, had been found responsible for sexual misconduct. I will refer to my son as John Doe, or JD, to protect his identity because of the substantial stigma associated with Georgia Tech's finding. This has truly rocked us to the core. We have been extremely blessed with two smart, sensitive, and caring kids, neither of which have ever been in any trouble. Our daughter just graduated from the University of South Carolina, and our son, a senior at Tech. JD worked while in high school, played sports, including being a team captain, graduated with honors, is an AP scholar, and even volunteered at a widow's farm in our community, doing yard work and helping her to feed her cattle. He was raised to respect women and taught to protect those who are most vulnerable. He is a member of the ROTC and will proudly serve his country as a pilot in the United States Navy after he graduates. When JD came to us and told us about Tech's findings, he was devastated. Naturally, we wanted to know the facts. What happened? On October 31st, 2014, our son went with some of his friends to a party on campus. Several of their ROTC friends were there as well, male and female. There was drinking, and JD was a participant. Later in the evening, some of JD's friends left to go for food. JD was left behind with a female friend from his ROTC unit who was intoxicated. On several previous occasions, JD had been asked to assist this girl when she was drunk. For example, she had been alone somewhere and called him to help her get home, or had gotten sick, and he was called to come and help. JD had become concerned about her behavior and had thought he should avoid her. But that night she was drunk. She was missing her key and locked out of her dorm room. It was unusually cold that night. It actually snowed. She had no coat, and it was after 1 a.m. ROTC teaches its members to take care of each other. So rather than let this girl roam around alone and drunk in the cold, JD did what any decent young man would do. He told her to wait with him at his apartment until their friends, including her roommate with a key, came back from getting food. They went back to JD's apartment. The girl told JD how she didn't want to be a burden, but she stayed until their friends returned about 45 minutes later with Krispy Kreme. Everyone ate donuts, and then one of their friends walked the girl home on his way to his own apartment. Her roommate was there and let her in. Once the girl was home, she texted JD to thank him for looking out for her. I would like to read you from that text. Quote, "I'm sorry I was bothering you, but I'll get my key. Thanks for being such a great guy." Unquote. As a parent of a boy and a girl in college, I can tell you this is a success story. Everyone made it home safe. The next morning, the girl texted JD, apologizing and thanking him again for taking care of her. She also asked him to hang out that day. You would think that this would have been the end of the story. However, another female upperclassman and ROTC member had concerns about this girl and her relationship with multiple male students in the ROTC unit. After discussing the October 31, November 1 incident with the girl, she became concerned that the girl may have been kept at JD's apartment against her will. So she reported it to her direct superior, who brought it up the chain of command to ROTC's executive officer. The ROTC formally investigated the incident. Although the ROTC found both the girl and JD were responsible for underage drinking, something JD admitted to at the outset, the ROTC found no wrongdoing on the part of JD with respect to the girl. In fact, JD has since had several ROTC recognitions for community service, sports, etc. The girl was eventually dismissed from ROTC for unknown reasons. Again, this should have been the end of the story. However, the ROTC was also required to report the incident to the Office of Student Integrity, or the OSI. JD was interviewed by OSI's director at the time, Peter Packett, and Molly Mayfield. JD told them what had happened on that October 31st night and how he had acted to protect the girl. While discussing the events of the evening, JD asked Mr. Packett what he should have done differently. Mr. Packett actually suggested that JD should have put this girl in a cab with a stranger to do what? Drive her around in circles until her roommate returned, whenever that would be? Would a cabbie have even accepted that fare? Was that really a safer solution? I think this demonstrates to you the complexity of the situation JD found himself in. To this day, we have not been able to come up with a plausible alternative solution that would have been better than what JD actually did. Soon thereafter, Mr. Packett informed JD that he was being investigated for 2 potential code violations, underage drinking and intimidation under the sexual misconduct policy. JD has never disputed the underage drinking, although it was surprising, at the OSI's discretion, that the girl was not charged. But as to the intimidation charge under the sexual misconduct policy, JD was devastated and confused. Per Georgia Tech's Code of Conduct, intimidation means you act in a menacing way with the intent to inflict evil or injury upon another. JD had acted to protect this girl. She was still sending him friendly text messages. She had not initiated this complaint. Mr. Packett, not the girl, was pursuing these charges. Georgia Tech's Code of Conduct explicitly applies to allegations of sexual misconduct. Students are supposed to have a right to a hearing and a choice for a decision made by a student conduct panel. JD was never given this opportunity. JD received a second email requesting he make another appointment with the OSI based on a need to further discuss these potential violations. JD had previously provided Mr. Packett the name of a key witness, the friend who had walked the girl home, and would be able to testify as to whether she was upset about JD's actions. JD also had provided the text messages he received that night and the next morning from the girl thanking him and telling him what a great guy he was for taking care of her. At this second meeting on January 8, JD discovered that Mr. Packett had not interviewed the key witness he had provided. Mr. Packett also refused to consider the text messages. He said these pieces of evidence were irrelevant. JD had believed that this key evidence would prove him innocent of any wrongdoing. Mr. Packett told JD that frequently text messages and witnesses are provided by the accused, and they are found guilty anyway. In addition, Mr. Packett obtained hearsay statements from people who were not even present near or at the time of the incident. Perhaps most troubling, JD did not have the chance to question the supposed victim to ask her if she thought he had done anything wrong. At one point, Mr. Packett told JD that he was intimidating, quote, simply by the fact that he was a male, unquote. It seemed as if Mr. Packett had already decided JD's guilt. Georgia Tech's Code of Conduct grants the accused other rights, including the right to be accompanied by an advisor and to call and question relevant witnesses. JD was given none of this. In fact, JD felt the whole situation and its gravity was downplayed and had no idea that OSI would actually render its decision without some kind of hearing or process. Here's a 19-year-old boy, new to this process, alone at this meeting with no witnesses, no evidence to defend himself, no advisor, and no support whatsoever. The very next day, January 9th, JD was notified by the OSI that he had been found responsible for underage drinking and intimidation under the sexual misconduct policy. Unbeknownst to him, the meeting the day before to discuss the potential violations had in fact been his hearing. JD was put on 6 months probation and given a suspension held in abeyance. JD appealed the findings to John Steen, Dean of Student Life, who upheld the charge with no explanation. So basically, one person within the OSI, Mr. Packett, filed the charge, investigated the charge, and found JD guilty of the charge. And there was no meaningful review of one person's determination. JD literally went from a young man who thought he was protecting a friend and a fellow service member to a young man guilty of sexual misconduct. How does this happen? After JD was found responsible for sexual misconduct, the supposed victim sent him text messages saying how sorry she was and how unfairly he was treated by OSI. She called him multiple times, has waited outside of his apartment refusing to leave until he came out, and called him drunk from a fraternity party asking for his help once again, all documented with call logs and text messages. Unfortunately for her, the one person she could count on to help her before was unable to help her anymore because of the way the university punished him for helping her before. JD was also forced, as part of OSI's punishment, to undergo a full psychological evaluation, a litany of tests to determine his aggression, power, and anger levels. His mental levels were all found to be in the normal ranges. The only issue JD's doctor uncovered were determined to be, quote, a direct result of the Office of Student Integrity's handling of his case, unquote, including high anxiety, a distrust of people, and a feeling that his voice is not heard. I will tell you that when all this started, it probably took 4 to 6 months of reading, research, searching for answers, reaching out to the numerous groups forming to protect the rights of those accused of misconduct and not getting due process before my husband and I began to fully understand what had happened to our son. We have spent many hours and many thousands of dollars in legal fees trying to find justice for him. Of course, no price can be put on the emotional damage that has been done to him. His college experience will forever be what happened to him at the hands of Peter Packett. Make no mistake, I see the hurt in his eyes, and I know the toll that has been taken as he has struggled to maintain his dignity in the face of this injustice. Tech refused for almost 2 years to consider whether they had made a mistake. Our family had to hire a lawyer to draft a 300-paragraph legal complaint before Tech finally did the right thing, reviewed my son's case, and dropped all charges this past July. Georgia Tech has refused, however, to give JD the apology he deserves from Dean Stein, who rubber-stamped Mr. Packett's appalling and reckless actions, or to reimburse the thousands of dollars in legal fees and psychological testing our family had to spend. It does appear that Georgia Tech has done one right thing, and that Mr. Packett is no longer employed there. I believe that this speaks volumes. Sexual misconduct is a horrible thing on a college campus or anywhere else, and our family strongly believes anyone who engages in such conduct should pay the consequences to the fullest extent of the law. But someone found responsible for sexual misconduct will carry that stigma with them for the rest of their life, even if they were wrongly accused. What happened to JD was life-altering. It cost him his lifelong dream of being a Navy SEAL. Had he been given the due process rights he is entitled to under Georgia Tech's Student Code of Conduct and the United States Constitution, this never would have happened. We must have a fair, objective process that seeks truth and justice. With so much at stake, with young lives hanging in the balance, this is our moral obligation for all parties. Those with the power must be responsible not to wield it recklessly. And I would like to thank you for letting me come today.
Thank you for your testimony. Members of the committee, we were here for the beginning of that last year. There are some outcomes. I don't see any questions at this time, so thank you very much for your time and effort. Next up, for those against, is Mr. Matthew Wolfson. Matthew, you here?
Yes, thank you.
Okay.
Thank you, Mr. Chairman.
You're fine. I'm sorry. Let's go ahead, Mr. Wilson. Sorry,
Thank you.
I was making sure that we had.
My name is Matthew Wolfson. I am a student at Georgia Tech. I also am the previous president of an IFC affiliate fraternity on campus. And of course, I'd like to thank the subcommittee today for allowing me to testify. I believe this bill is crafted with genuine intention. I am part of the demographic that makes up the majority of respondents in campus sexual assault complaints, white, straight male. So when I see a bill like this, I see that I'm just the type of person that this bill aims to protect. And I'm thankful to know that I have representation here today, and that elected officials here have my back, so to speak. And it's this concept of looking out for each other that I wish to talk about. I am not a survivor or a victim of sexual violence, but I am what some people refer to as a secondary survivor, which is I am the first person a victim goes to for help. A woman who is a good friend of mine came to me when she was overwhelmed by the trauma of her tragedy. And I am not an expert when it comes to giving advice to victims, but she clearly needed help. So I talked to her, and she made it very clear that she did not wish to report to the police. She did not want to talk about her private trauma as a matter of public record or testify in front of a jury of complete strangers, which is why she came to me instead of any authority. And I thought it was best to go to the school with this. So at Georgia Tech, we found support services, and with these support services, we discussed the options for reporting. My friend's right under Title IX, and the steps she could take to get things to be better. Ultimately, she decided to take a leave of absence for a semester. We came to an agreement with the accused member to maintain separation, and I'm happy to report that as a result of the help she received from the university, she's doing well in school, has a high GPA, and she's made extraordinary progress in the emotional healing process. And she's not the only one who benefited. I've not been in contact with the accused since then, but in talking to his friends, I've learned that they believe that he has learned what he did is wrong. He's taking the appropriate steps to correct his behavior with a counselor. And this resolution was only able to be achieved because we had the support services from Tech, and we were able to go through this without the entire process of criminal prosecution. But it would not have been possible with this bill, HB 51, in place. My friend would not have been able to turn to the university for help, as what happened to her would have been reported to law enforcement. I would like to point out that the support advocacy programs that employees, their employees typically do not have a clinical social worker's license. This is a program, of course, that the school constantly advertises as a place to go to if you are a victim. And they do not have, by Georgia state law, they don't have privileged information rights. So as such, the people who are advertised for you to go to, if you bring your case to them, they would report you most of the time, depending on the case, if they believe it's a felony. My friend admitted to me that if this criminal investigation had been initiated, or if she wasn't able to receive assistance from the school, she would have transferred to a university in another state. Quality education that she had sought, Georgia Tech, would have been a complete pipe dream. And it's exactly this is my chief concern. If someone had been sexually assaulted, how could they handle staying at the school they're violated if the place that is advertised for you to go to would report you? That is a big concern of mine, and I'm afraid that a bill like this would silence them. And as we continue the hearing today, I beg you to ask yourselves, where would these victims go, if not to these specialized services? Where would they go? Who has their back? Thank you.
Thank you, Mr. Wilson. Any questions from members of the committee? Thank you for taking the time to testify, sir.
All right, thank you.
Next is Mr. Jonathan Hawkins. Mr. Hawkins.
Thank you, Mr. Chairman. Thank you, committee members. My name is Jonathan Hawkins. I'm an attorney here in town. I have represented a number of accused in student disciplinary proceedings, including sexual assault allegations. I'm also personally aware of other matters that I am not involved in, and I bring all of that experience to you in my testimony today. I was here before you last year, and since that time, the hard work that, Mr. Chairman, you've done and the committee's done and the Board of Regents, there's been a new policy in sexual assault cases promulgated and in force, which is better than what was there before, but it still doesn't go far enough, in my opinion. And I'm going to talk, about some of the things that I have personally seen in the matters I've handled and some of the problems that I think are there that need to be addressed. So let's first talk about the investigation process and the investigators. These are school administrators. From my experience, they are not lawyers, they're not judges, they're not police officers, they're not former police officers. They are just administrators, educators. From my experience, they lack training to be investigators. I'm still not exactly clear what training they do get. I've been told maybe they get 2 or 3 days of Title IX training once. I don't know what the materials are. I've never had the opportunity to see what the training materials are. My understanding is there's no recurring education yearly or quarterly or wherever where they rehash or relearn or refresh themselves or perhaps learn new things. It's one-time training and then they're certified and that's it. Let's talk about the investigation process. Most of these cases, the sexual assault cases, are he said, she said. No one's there. And so it's credibility is key. And you try to piece together timelines. And nowadays, with digital technology and video surveillance cameras and the like, there's other sources of evidence that should be sought and looked at to confirm timelines and that sort of thing. Well, under the current regime, these administrators do not have subpoena power. And as someone who represents the accused, I don't have subpoena power. If there are cell phone records, digital timestamps, or video surveillance that might prove what my client says happened, where he was at certain times, I have no ability to go get them. I was involved in one case where there was video surveillance. We knew it was there. We asked for it. We were told that it was on a continuous overwrite loop, and it had started to overwrite, so therefore they couldn't get it. So I said, well, preserve it so we can look at it later and get a digital forensic computer expert to take what we needed off of it because that can be done. They refused to do that, and they said, well, if you pay us, I think it was 10 or 12 grand plus the hours that it takes, then we'll think about it. And my client and his family could not afford that, so we didn't go that way. I'm not a police investigator, but I would imagine typically we'll hear from some, when I see things happen on the news, within a few weeks you have surveillance videos from all over the area that they captured. And these investigators didn't even think to do that. I would think professionals would think to do that and would get it and would have the power to get it through subpoena or other means to get it. Another issue is, a lot of those students nowadays use Snapchat, these other apps that you send a text and it disappears. And so if you can capture cell phones and forensically image them, you can get what you need to, again, confirm or deny sort of the stories that are going around. And I think both sides, both the accuser and the accused, would like that kind of access in the investigation. I think that's something that the current regime does not allow. Now let's talk about the interview process. So the investigators go and interview various witnesses. Well, these witnesses are not sworn. We don't know, there's no transcription, there's no video recording, there's no audio recording, so we don't know exactly what's been asked and how the answers were there, other than just notes that were taken in a report that's produced months down the line. And these cases, again, he said, she said. It's all about credibility, and if you don't know the questions that were asked or the questions that were not asked, how can you adequately defend yourself if you've been accused of something like this? Now, after the investigation is heading towards conclusion, the investigators create a written report that includes all the statements, other evidence that they may have gathered. And from my experience, these reports are full of unreliable hearsay testimony. It's interesting, too. You have these 18-year-old, 19-year-old kids giving medical diagnoses and other expert opinions as to, what happened to the accuser and all the things that in their opinion, were wrong. And again, the investigators seem to rely on these 18, 19-year-old expert opinions, and they've got no training in this sort of thing. It should not be included in the report. The reports contain a lot of irrelevant narratives that have nothing to do, really, with the time at issue and the facts at issue. And I'm not sure why they put it in there otherwise perhaps to prejudice the accused. That's my experience. The other thing, in these investigative reports, the investigators make an initial finding of responsible or not responsible. And the reason that's important is because when you get to the hearing, which I'll talk about in a minute, the report goes to the panel members. It goes to the jury members, in effect. So the jury members, as part of the proceeding, see these reports, they see the hearsay evidence, they see these expert opinions, they see stuff that in a normal court would not be admissible, and it taints their view on the case. I've seen it firsthand. Now, the hearing process. This is another troubling aspect of these proceedings. From my experience, no one really knows how these things are supposed to take place. It's as if they make it up as they go along. I've done this a number of times, and each time I go in, it's sort of a different story about how the hearing is going to proceed. And so I really never know how to adequately defend in this situation. From my experience, another bad process here is during the hearing, they separate everybody into separate rooms, potentially three separate rooms. You'll have the accused and their witnesses there, the accuser there, and then the panel in another room, and it's all video conferenced. Again, witnesses are not sworn. There is no right to directly cross-examine the witnesses. At best, you can write down questions, or sometimes you can have a live sort of text feed to the panel members and say, ask this question, and they may or may not ask the question. And if they do ask it, they may not ask it exactly the way you wanted it to be asked. And it's just not a good process. As a lawyer, if somebody says something, I want to be able to ask them immediately a follow-up question. You can't do that in this process. You've heard a little bit, I know the committee knows, evidence rules don't apply. And that is extremely troubling for a lawyer. There are reasons, hundreds of years of jurisprudence have, we as lawyers and judges and a society have sort of determined what sort of evidence is reliable and what is not. And the courts have pretty much settled on that. And these matters, it's just out the window, doesn't apply. So basically anything comes in. But even if there were evidence, let's say you guys put some sort of evidence requirement on it, the panel probably aren't going to be lawyers or judges, so they're going to have no real experience or ability or knowledge about how to deal with it anyway. And that is just a really big problem from my perspective. And again, you've heard this a lot, but the evidentiary standard is just too low. And as Representative Seltzer said, these cases are very serious. This is basically, could be an academic death sentence to an accused that follows them for the rest of their life, alters the course of their life, and they will never recover from it. This is very serious, and we need to make sure that this process is conducted in a fair way. Now, after the hearing, another issue I want to touch on is appeal rights. In a criminal case, if a defendant is found not guilty, it's over. The prosecution doesn't get to appeal and say, hey, we want to try it again, typically. In this process, at every stage, if the accused is basically found not responsible, the accuser can say, no, I want to appeal that. So then it goes to the next stage. And then they get to appeal again at the next stage. And so, the Georgia State Constitution, U.S. Constitution, there's provisions about double jeopardy. Well, that's just out the window in these proceedings. So as an accused, if you think you've won, well, you haven't necessarily, because an appeal's probably coming. And I've dealt with that personally, and the financial and emotional cost on my clients and their families is extremely burdensome. Now, there's another issue that I'd like to discuss. I believe Representative Golick mentioned this last year at the hearing about the interplay between this and the criminal process. Well, since the hearing last year, I have come to learn about 2 examples that really go straight to that issue that I want to share with you. The first one, the male student, lived off campus with a non-student female girlfriend. She accused him of domestic abuse, reported it to the school and to the police. He hired a criminal defense lawyer who told him, do not talk to the police, do not talk to the school, don't talk to anybody while we sort this out. He asked the school to put their proceeding on hold while the criminal proceeding played out so then he could come back and defend himself. The school refused. They moved forward without him, expelled him, kicked him out of school. Ultimately, the criminal charges were dropped. He's completely exonerated there. Went back to the school and said, hey, I've been exonerated, let me back in. They said, no, we're not going to let you back in. But if you complete this month-long weekly domestic violence course and certify that you've done that and you reapply, maybe we'll let you back in. Well, he did that at his own cost, his own dime, got back in, eventually graduated, and has moved on. But now he's got a permanent blemish on his record. He can't go to grad school, can't go get an MBA. He's pretty much stuck with this on his record forever. It doesn't make much sense to me in that situation. And there's another example that I know Mr. Chairman is aware of at a different school where sexual assault allegations been made, reported to the school, reported to the police. After multiple interviews and investigation by the police, they've determined that the accuser is not credible and that there's no probable cause, no charges have been brought. Well, this person's attorney brought that finding to the school and said, look, we've basically been exonerated here, and the school said, I don't care. We're moving forward. And so now this person still needs to defend himself, spend money, pay a lawyer, go through the emotional roller coaster of the school proceeding when the criminal justice system has basically told him, we're not coming after you. A few other issues I'll bring up. I've seen instances where both the accuser and the accused transfer out of the school, and the school decides to keep going forward with the investigation. I'm not sure why. I'm not sure it's good use of resources. But again, my client had to continue to spend money to defend a case to make sure his record would be protected, but he wasn't even at the school anymore. Same case, Mr. Chairman's aware of, my client actually transferred to another school. The accuser found out about it, made a report at that school. The new school opened up an investigation while the old school was still investigating on their end. So there, in effect, 2 investigations started on the same incident, one at a school that it didn't even happen at. Luckily, we got the second one taken care of, but still, I mean, it makes no sense. And in conclusion, I'll just say I've seen firsthand the emotional and financial cost that a wrongfully accused person and their family goes through. Attempted suicides, a lot of other things, therapy, that is just, it's heartbreaking to see, and I know that they're innocent. I have a daughter who's a freshman at UGA. This is something that is very serious to me. I want her to be protected. I find, sexual assault is a serious issue, and I think everyone needs to be protected, and campuses need to be kept safe. But we shouldn't trample over the rights of the accused to get there. And with that, I'll take any questions.
Thank you. Any questions from members of the committee? You have a question from number 7, Representative Fleming.
Thank you, Counselor. You practice criminal defense law?
No, sir.
This area you're talking about is your specialty?
I have become very experienced over the past year and a half, but it's not my specialty, so to speak.
Do you have a copy of the bill?
I do not.
Yeah, something right there. On the second page there on line 53, it makes a reference to OCGA 245501, which talks about communications that can be excluded from evidence. I cite that because I'm going to ask you now to turn back to page 1, line 23 and 22 of the bill. This is the reporting, mandatory reporting that was referenced earlier. And it says,
I just have the second page.
We got several folders.
No, thank you. Thank you. I appreciate that. I'll reference line 22 on page 1 right there. This is the mandatory reporting that was referenced earlier. And before you testified, there was a concern that somebody would have no one to talk to if this bill were to pass. Line 22 says, every post-secondary institution in this state that receives information other than information provided to an employee privileged under the laws of this state. And that's what I'd like to focus on with my question right there. Unfortunately, I had to go to another meeting and miss some of the discussion here, and this may have already been discussed. But I pulled up OCGA 25-5-501, and here are some of the people which privileged communications are allowed. In other words, there would be no cause for mandatory reporting, and this is just a small portion of the list. Communications, subsection 7 says, communications between a licensed clinical social worker and the patient would not have to be reported. Communications between a clinical nurse specialist and psychiatric/mental health would not have to be reported. Licensed marriage and family therapists would not have to be reported if you talk to that person. And here's most importantly, a licensed professional counselor. Any student could go to anybody employed by the university in that capacity, which is very broad, a licensed professional counselor, and there would be no mandatory reporting. Is my understanding of what I'm reading here, do you think, correct as far as you know?
As far as I know.
Thank you.
Thank you, Representative Fleming. Mr. Hawkins, just one question. You've practiced in this area. Would you say that the state's liability to this point has been fairly significant with respect to the settlements that are out there? I don't expect you to talk to them specifically, but let's just say in the significant hundreds of thousands of dollars to the state, and there are still ongoing cases that the state has a liability to risk for?
Yes, I would agree. I know that there's some public settlements with some six-figure dollars, and I know personally know of others that could come. I don't know if they will, but they could.
Isn't it correct that the panel put together by President Peterson himself for the regents indicated that there were significant due process issues during that time?
Absolutely.
So the state, in effect, admitted a due process concern.
They issued a report on that.
How would you like to be the attorney on the other side of that? That's a rhetorical question. All right. You got another question from number okay, 3, Chairman Sessler.
Thank you, Mr. Chairman. Mr. Hawkins, appreciate you being here today. You highlighted some concerns that I'd shared earlier. I wanted to just kind of get clarity on what your experience is. So it's your experience that the hearing process itself is inconsistent, unpredictable, non-standardized. Has that been your experience?
That is correct. I have asked, do you have a written guideline as to what the hearing would be? And then it's usually the response is, well, we'll have to get back to you.
Sure. No, we've got. We have broad powers within. We give the cities in the Constitution. They have certain constitutional powers and set up municipal courts and so forth. But there are certain rules of the road, as it were, to holding court proceedings. There's a process defined in state law that lays that out. Do you think it would be helpful to the process if there was statutory clarity on what the process looks like, rather than just sort of pitching it to the university system to figure that out? I mean, in your opinion?
I think clarity would be good. I don't know. I'd have to see it.
For purposes of uniformity, sure.
Yes.
Two further quick questions, Mr. Chairman. So, you believe the rules of evidence, if they were followed and they had people who were competent to sort of follow that process, to keep hearsay evidence out, and really provide the kind of integrity of the process that we would normally expect in a modern society. You think that would have a dramatic impact on this? From what I understand?
Absolutely.
And then lastly, it's what I'm hearing you say, similar to perhaps what Ms. Starling alluded to, was there be real clarity, perhaps a clear and convincing standard on something that's I don't want to put words in her mouth, but I do think what I heard her alluding to was great clarity if there is a final adjudication or a sort of a disciplinary. If discipline was going to be brought, you believe, as I think others have sort of contemplated, what is preponderance of the evidence for something like that acceptable? I'm hearing you say that a clear and convincing standard really is the only would be a responsible approach to this.
It needs to be higher than preponderance. This is the stakes are too high.
And is it true that there be one standard that folks uniformly understand, so that you have the same application in Valdosta State as you would have at West Georgia as you would have at Kennesaw State or Georgia?
Yes, I think it needs to be uniform statewide.
Thank you. I don't see any further questions. Thank you for your time for coming today.
Thank you.
Thank you, Chairman Sessler. Okay, next up is, I lost my notes, Ms. Jessica Caldas. And next will be Representative Quick and Sheriff Berry. Has Danny Porter arrived? Okay, I'm just trying to get an idea of how much time we have. Take your time.
Good afternoon.
I'm not running the clock, so take your
I want to thank Representative Earhart and the rest of the committee for your time and consideration today, as well as in the past few weeks. I truly appreciate your seriousness and the thoughtfulness with which you consider this bill and the concerns that we have. My name is Jessica Caldas, and currently I'm a graduate student at the Georgia State University. I was raped by someone I knew as a freshman at the University of Georgia. Not only was this person someone I knew, he was someone who lived in the same dorm as me, one floor below mine, someone I encountered frequently in my time at school. After my rape, I attempted to maintain a normalcy in my life at school. The time following my assault is hazy. I remember sleeping more than I should have, and my once social life became stagnant. I attempted to attend classes normally, but my previously solid grades dropped. More than anything, I did my best to avoid my rapist, with varying degrees of success. The one thing I did not do was report my rape. I told my mother, who carefully supported me in figuring out what I wanted to do, but I never told the police, and I never told anyone on campus, not even the doctor who observed my tears through the emergency STI tests that I did seek out. My decision to not report my rape may be difficult for some to understand, so I will do my best to explain it to you. But more than anything, you must remember that it was my choice. Rape is an extreme violation of another's physical body. Not only that, but rape is an attack on a person's autonomy. When one person assaults another, they are taking away their agency and attacking them at their core. It is ultimately dehumanizing, a refusal to acknowledge the humanity of the one being assaulted. This dehumanization, along with the stigma of sexual assault, breed within the victim doubt, shame, fear, guilt, and the sensation that nothing will happen or change what has happened. And for me, it was enough to stop me from reporting. This trauma feels almost impossible to respond to, but what is vital is for the choice to be left to the victim. HB 51 will continue to threaten the agency of victims, perpetuating the violence against them by continuing to steal their chances of making autonomous decisions without limits. Any kind of mandatory reporting law, like HB 51, are dangerous for victims and for schools. These laws are proven to have a chilling effect on rape reporting. Victims know that the criminal justice system will put them through a lengthy and invasive process, for which many are not immediately prepared for while dealing with the trauma of their assault. If they know they will be sent to the police, victims are less likely to report at all. This means campuses become more unsafe, as less students choose to share their assaults, even with campus specialists. Additionally, mandatory reporting laws assume that the answer to the problems in the administrative process is the criminal justice system. But this forces victims into another flawed system, where only a quarter of reported rapes lead to arrest, A fifth of arrests lead to prosecution, and only half of those prosecutions result in felony convictions. Some laws do not even recognize certain victims, such as men or victims of the same sex as their perpetrators. Essentially, the answer to problems within one system cannot be another flawed system. Ultimately, both the campus sexual misconduct hearings and campus administrative processes, as well as the criminal justice system, are important tools for victims for very different reasons. Neither system is perfect, but they are continuously being improved, and for that I am grateful. Most important is the victim's right to choose, without limits, who they need to share their story with, and which system, whether both, one or neither, best serves them in their path to recovery. I urge the committee to protect victims from re-traumatization by forcing them to report to law enforcement, to protect their humanity and their right to choose how best to heal after the trauma of their rape. Thank you, and I look forward to any questions you may have.
Thank you for your testimony. Any questions? Representative Fleming.
Thank you for being here today. The statistics you just quoted on rape, the reports, the convictions, so forth, are those Georgia statistics?
They're the Rape and Incest National Network statistics.
So they're not, they're nationwide?
They're national statistics, yes.
They're not Georgia. Okay, thank you.
Is that you, Chairman Golick?
Thank you, Mr. Chairman. Just a quick point to make sure that there's general clarity. And this goes back to Representative Fleming's line of questioning earlier. As I understand it, if an individual, if there's an attack or any other crime, frankly, if they were to go to one of the litany, the long list of individuals, including a licensed professional counselor and others who are trained and equipped to deal with situations and sensitive situations like this, if that individual goes to such a professional who's captured under the applicable code section, that's a privileged conversation, and therefore there would not be the mandatory reporting. I want to is there clarity there?
So while I understand that there are some options for a victim to report to, should they not want to be required to report to the police, the fact is that we are still limiting victims' choices by suggesting that they cannot tell their story to who they need to without repercussion, and forcing them to go to law enforcement is a repercussion. I want to be clear on that.
But respectfully, they're not being forced to go.
But
to
if
law
they go to
and
someone,
neither is the individual with whom they have the privileged conversation. Is that clear?
if it's the specific list that you've identified in the bill as it's written, which is listed here, and I could list them again, but I feel like we're all pretty aware of who those privileged individuals are. But as some of the other testimony has pointed out, a victim's first instinct may not be to go to a privileged counselor. I'm not even sure necessarily that all counselors that serve students on campus are officially licensed in the ways that are mandated by this particular code. Additionally, if I go to a professor, if I went to my RA, a residential advisor, if I went to the specialist, the Title IX specialist that I know to be educated on this type of assault, they're all required to report to the police, which means that I have officially lost my choice in who I think is the appropriate person to tell my story to. And that choice is the most vital for victims.
Thank you.
Chairman Sessler.
Thanks for coming today. Really, this change, this is your involvement of folks like yourself makes this very meaningful, very, very real. I'm just wanted to ask you that you do have a sense on campus that a Title IX specialist is a safe person to go to on campus. Is there a general sense of that?
I'm not sure if because of sort of the work that I do as a student and as a person in life, I have more awareness of that or not, but
Okay.
I am generally aware, yes.
Okay. So there is a sense that I'm assuming most rape victims aren't going to know the Title IX specialist on campus until they're just thrust into this circumstance and just against their will, obviously. I mean, this isn't a proposal, I'm just asking if a Title IX specialist were, I mean, if you replace Title IX specialist with counselor, then that's that same relationship one thinks about in going to a Title IX specialist would seem to be very easy to redirect to a counselor, or perhaps a Title IX specialist, I'm just thinking out loud, could be a counselor, could possibly even be a non-reporter. But what I'm hearing you say, there is this sense of there are places to go on campus that because they're designated as safe places, people go there and they feel safe telling their stories. Is that fair to say?
I think that's fair to say.
Okay.
But I would like to once again reiterate that any limits to where a victim chooses to tell their story is, I think, flat out wrong. So.
And I hear that.
Sorry.
Sir, Mr. Chair. And I'm just trying to understand, I mean, for purposes of parsing this issue, because, I mean, I think anyone can see strong arguments on the sides of this as the legislature tries to parse this issue and understands where to land. You know, there may be an open question that whether a Title IX specialist ought to be a mandatory reporter or not. Maybe the direction kids kind of get in school is a counselor. That's maybe something we can decide. But what I am encouraged to hear is that people who are going through this tragedy, there are places on campus that have been identified they go to and they feel comfortable going there. And I think that's an important distinction. Now, I understand you don't believe there should be any limitation, but it's instructive to me that there is a sense that if this is where people are supposed to go, they go there, and there is a sense of comfort in having that discussion. And I think that's important, because whether it's a Title IX specialist or a counselor, I think we do get this sense that if there's a safe place on campus to folks to go to, that those people can be prescribed or for students, and if they're not mandatory reporters, people know that, and there's a safe place to go where this process isn't going to get kicked off. That is supportive of the approach that Representative Earhart's bill is taking. I think it's important to me.
You have two more questions. You okay with that? Okay. Representative Fleming.
We deal with very difficult issues here sometimes. Last session, I chaired a committee where we changed Georgia's laws to try to keep people from sexually assaulting children. We had to find a balance between what we call old cases that were never reported and years later where evidence is very hard to come by but still allow people to bring an action against someone who had violently assaulted a child. Assault in any arena is terrible, whether it be an adult, but something seems to be even more horrible about doing that to a child. It was very difficult. It seems to me here we're faced with another very difficult balancing act. You heard stories by the attorney that testified earlier about some things that really seem to be out of whack on the other side of here as far as how some people were treated. It seems to me that's what this bill is attempting to do, to find the appropriate balance between two terribly difficult situations. And no government, no committee, no institution of man ever gets it exactly right. We're dealing with flawed people in terrible situations. But my basic question to you is this. I want to make sure and give you the chance to at least acknowledge that there are situations where the whole thing is out of balance, and there have been abuse on what I will refer to, for lack of better examples, the other side of this equation. Do you acknowledge that?
I think based on the testimony, no one could not acknowledge that there are times when abuses are put in place or perpetrated. And I also acknowledged in my own testimony that both of the systems that we currently have are flawed. I think that there's room for improvement in the criminal justice system, and I think there's room for improvement in the campus administrative process. And what I'm very excited about is that recently the University System of Georgia introduced a new sexual misconduct policy, I believe as a direct response to a lot of the hearings and concerns that we all have about due process that were introduced last year. That new policy has been in effect for only one semester. And I think that there's room for improvement even on the new policy, but I think that it's wasteful to not give that administrative process the chance to be tested, that new, very new policy to be tested and to be grown and to be improved so that due process is protected, especially since that policy was a direct result of all of the concerns you guys have expressed today. In addition, I think the criminal justice system can also be improved, but those are two separate systems for two very different reasons, and that's very important that both remain separate from each other because they provide very different protections for victims.
Okay. Thank you for your testimony.
Chairman Knight?
Thank you. Mrs. Caldas and even to Mrs. Starling, I mean, two people have experienced such a horrible, horrible event, life-shattering event. I think everybody in this room hates that. I mean, and it is so unfortunate. In fact, you know, I know we wish we could take people like that and send them away somewhere, never to see them again, ones that are guilty. But I also noticed in the testimony, you each had choices. And Mrs. Starling, you said that, you know, you took control of your life and you made a choice. And you likewise have made a choice not to do this. And it seems to me that the testimony here is that we're not in agreement or in disagreement that we've got a system that is flawed on the back end of giving due diligence to or going through a due process for people who are accused. But that, and I'm sorry, that's my wife calling or texting. My apologies, Mr. Chairman. I'm sorry about that. I'm glad she didn't. Glad she didn't call. My duck would have gone on. But it seems to me that this piece of legislation has attempted to do exactly what y'all have done is put a choice in there. And I know you talk about limitations and you want to be able to talk to whoever, and I know Mrs. Starling said she immediately went to, I think it was a professor, concerned with grades. But this is a heinous act. This is just not, you know, we shouldn't be worried about our grades all of a sudden. I mean, this is more serious. And we heard testimony from Mr. Wolfson, I believe, that he went and there was actually a advertised place on campus that provided those services. So it seems to me that there is a mechanism in this bill, and if there needs to be something, and I'm not going to speak for the chairman, but if there is that place that you need to go and you need to talk to somebody who there's probably a reason these are licensed people who can keep confidentiality because they probably by their training or education are equipped to deal with this, probably more so than a professor or any other person on campus, that they would be a great place to go. And if there would, you know, maybe certain work that would make sure that for folks like you who have experienced this horrible, horrible life experience, that you could go to somebody who's trained like that and make your decision as to how you wanted to go forward with this. That would give you guys, and I think that is the mechanism that I'm seeing in this bill, or at least I don't want to speak for the chairman. I really don't. But I don't think anybody's trying to force somebody to say, you've got to go to the police and go a different route if you don't want to. And I believe me, all the people up here that I know these people and I've served with them, I mean, they've got wives, you know, daughters. I mean, this is horrible, and we're trying to deal with the situation. But I would think that this mechanism in here is a mechanism. If it should need some work, or we need to look at specific, maybe how to tailor this in Georgia so that there is a place where anybody who's unfortunate as you to have experienced this could go and would know where to go, where there's someone who is trained, who is licensed, that you can go and confide in them and have time to get your thoughts together, decide how you want to go forward with this. That's what I see in this bill. And I again, I'm sorry this has happened to you guys, but this is very serious. And I appreciate y'all coming and giving your testimonial here.
I have a question from Representative Jones.
Thank you, Mr. Chairman. I don't know whether to direct this question to you or to Ms. Starling, but I would like to know, would a victim's roommate who works at the campus library be required to report?
That would be a student communication.
Okay.
But if they're employed at the library, I think is the point of the question.
And what about an athletic coach?
No, they're not, they would not be a privileged communication.
And if a trainer sees injuries? Okay.
We can hear you.
Okay. Should I repeat the first question? Well, I was asking, an athletic coach would, coach would not?
An athletic coach would not be a privileged communication.
Okay. And an athletic trainer who notices injuries?
Unless they're,
No. Okay.
but I don't have the entire list. I'll provide you with a list of 26. So
Okay.
that's the list of privileged communications. There you go. Somebody had it.
Okay.
Thank you, Representative Jones. I don't see any further questions. Thank you.
Thank you.
All right. We have, let's see. We have one more against. We have two more in advocacy. We have Representative Quick and Sheriff Berry, and then Helen Robinson, and then understand DA Porter is outside, so he'll be the last. Okay? Representative Quick and Sheriff Berry from Oconee County. And everyone, I appreciate the long hearing and everyone standing. I wish I had enough seats for everybody. And I certainly appreciate the tone and tenor of the discussion. Thank you, Mr. Thanks, Sheriff. Representative Quick.
Mr. Chairman, thank you for allowing me to make a very special introduction to the committee. I have brought to you today Sheriff Scott Berry from Oconee County. He started his illustrious law enforcement career in 1978 with the University of Georgia Police Department, moved on to be an investigator with our Clark County DA's office from 1980 till he was elected sheriff of Oconee County Sheriff's Department, Oconee County Sheriff in 1992. That's when he was elected. 2012, he was the president of the Sheriff's Association, and with him today also from Oconee County is his chief, Lee Weems, who has been chief deputy in Oconee County since 2009. He was also at University Police, the campus police force, for 10 years prior to that, and he is an adjunct professor of political science at the Georgia Military College. Also want to thank you for allowing me to work on this bill, and I hope I brought someone who can bring, I know we're short on time. There'd be a lot of legal things I might like to say while I'm up here, but I hope I've brought someone who can bring some facts and help perhaps allay some of the fears of how these investigations are conducted. From a law enforcement standpoint, we have the university, not just their experience with the University of Georgia, but we have the University of North Georgia in Oconee County within the sheriff's jurisdiction. And coincidentally, there was a report of yesterday that he can certainly talk about and walk the committee through the actual process that law enforcement goes through. I've asked him to deal generally with some topics about I know he's going to share some personal stories with you, but I want the committee to hear about the balancing that we're doing that we haven't heard about yet, which is campus safety. Because from my perspective, I know that Chairman Earhart has his view, and when he asked me to co-sponsor this legislation with him, that might have been he might be sorry that he did as we've gone through this process. I don't know, but he's very passionate about one aspect of this issue. And so the law is reason free of passion, or at least supposed to be. That's either Aristotle or Elle Woods in Legally Blonde. Take your pick for that. But what I've tried to do is to take that balancing approach in looking at this, and he has listened to the folks who have brought him these concerns, and you will see significant. I wish everybody in the audience had a copy of the bill, Mr. Chairman, because if they've looked at it online, it's no wonder some things that have been said perhaps don't match exactly to what the committee is looking at, and that's because you have listened and made changes in all aspects of the bill, which I won't go through in the interest of time, line by line and subject by subject in the changes, but we could. But from this perspective, I need not remind anyone that we have a responsibility to the students on campus, because in the infinite wisdom of some, it is a gun-free zone, and students are at the mercy of the protection that we provide them. And so we have to look at campus safety concerns this reporting requirement serves that function as well, because with 30 years in Athens of working with the Rape Crisis Center, and as a passionate co-sponsor of Representative Holcomb's Pursuing Justice for Rape Victims bill, I come at this from a different place, and that is that we need to make sure there are no more victims of any felony on campus, and rape is a serial predatory offense. So I apologize for the point of personal privilege, Mr. Chairman. I'll turn it over to Sheriff Barry.
You're certainly welcome. You've been a major part of this, and I don't regret any minute, especially with the perspective. Thank you, Mr. Sheriff.
Mr. Chairman, I want to thank, recognize my other representative, Chuck Williams, serves on this committee, and the work I've done with many members of this committee over the 24 years I've served as the sheriff of Oconee County. I'm honored to be here, and I'm honored to discuss this, and I've got some. I need to speak what's on my mind, because I think when I first saw this legislation, I met with Regina at our courthouse, and we ended up, the deputies actually locked us inside the building. We were in there talking about this line by line, and I looked at the language on some of the lines, and I worried that it wasn't permissive. And we asked that language be changed. And I'm not sure which version of this bill people have been looking at, but there is nothing in this bill that I've read in this current form. I'm talking about 8277S.
That's what we'll work on.
And that's the only bill I'm concerned with right now, because it's one in front of this committee. There is nothing in here that makes me do anything. There's nothing in here that makes me as a peace officer do a thing. I don't have to investigate anything. I don't have to know the name of a victim. There's nothing in this piece of legislation that's currently in front of me that would hinder any rape victim from cooperating with me or not as he or she sees fit, or a victim of any crime. This has the word whether in it. There's no requirement that any institution give me the name of the victim. I know it. I know what mandatory reporting language looks like, because we have it in our child sexual assault statutes. I've read that language. I know what that language says, and we've worked on that over the years. There's nothing in here that would keep any student or any human being on this in the state of Georgia from me having to do anything. And I'll give you an example. Even if this were law now, 27 hours ago, we had a male student report an assault, a sexual assault on himself in the bathroom at the University of North Georgia. We had a male student report that he was sexually assaulted in a bathroom on the campus of the University of North Georgia in Oconee County, which is about 1,000 yards from my office. I don't know who he is. We don't know anything about it. We were told, but we don't know, he doesn't want to report it to us. And we're not working the case. I've got my people with me. As you know, if we were working that case, they wouldn't be sitting in here all day. They'd be working on that case right now. And there's nothing, there's nothing in this piece of legislation that changes that.
That's correct.
I'm worried about the previous version of it, but that's been corrected in this language, and I'm extremely satisfied that there's nothing in here that makes anyone identify any victim of any crime to me whatsoever, or any other peace officer in the state of Georgia. I want to, previous witnesses have testified to the problems that are run on ad infinitum with parallel investigations by untrained, unqualified people who don't have anybody's interest other than coming to a conclusionary report that's handed out in some proceeding where no one's represented. Obviously no one in the state of Georgia wants that. You can't reach conclusions based on somebody else's reaching of conclusions. We don't conduct business that way. We don't do things that way. There's in sexual assault cases, when one is reported to us, not just when we're told that one exists, but when one is reported to us, My people have 24 hours to gather evidence, interview victims, make sure that whatever evidence is out there has been gathered correctly. We have obviously our sexual assault nurse examiners in Athens. We have a whole process we go through. We can't have a parallel investigation by untrained people or a halfway investigation by untrained, unqualified, unknown people running parallel to that. I've got a guy I need to put in the chain gang if he's guilty. And that's much more important to me. And that's much more important to a victim who has chosen to report this to us. Mm-hmm. I hope I can address some questions that this committee may have.
Thank you, Sheriff Berry. I appreciate the passion you bring to this. It's very clear that you have a victim-centered approach to law enforcement, and I appreciate the statements from Representative Quick and for you. We've worked very hard to strike a balance on this reporting. The public safety issues, campus safety issues, the idea that we need to remove from society these people. An administrative procedure on a university campus doesn't remove that person from society, does it?
No, it does not.
You can.
I can and do. And
thankfully so. Okay, you've got several questions, Sheriff. We'll start with Representative Fleming.
Sheriff, thank you for being here today. I want to make sure I understand what you're telling us now. You just talked about, I believe, the fact that currently some of the investigations that may occur on college campuses would actually prevent you, once you get a hold of the case, from helping the district attorney put the perpetrator behind bars. Is that correct?
There's no question about that. I didn't want to go in, it's late, and I don't want to take up too much of this committee's valuable time, but there's two defenses in a sexual assault case: identity and consent. That's it. There are two defenses, and when we take a case, we have to overcome two defenses, okay? Because either I didn't do it or I had consent. So we've got to find that evidence right now. Okay, and key in that investigation is the sudden outcry witness, the first person the victim told, which would be in one of the instant cases here, a professor. We'd want to talk to the professor. I can't have other people going around talking to my witnesses. I need to be able to talk to my witnesses. I need to be able to preserve their statement for the district attorney, because if a victim's going to come to us, we're going to do our best. If assuming we got a case, we're going to put him in penitentiary for the rest of his natural life. And I can't do that if I've got other people untrained running around asking a bunch of. I have a hard enough time doing it in the age of social media now. But I certainly don't need any more incompetent help from other investigators that I don't know what it is they're doing.
So the summary of it is, if we were to pass this, it would actually make it easy for you to put rapists behind bars.
I think it would, yes, sir.
Thank you.
Is this you or Chairman Jesper? This is Chairman Williams.
Sheriff Berry, thank you and your team for being here today. Good to see you as always.
Thank you.
I've got a question that you just triggered, and Ms. Quick, you've got the bill in front of you, I believe, where line 26 says that the institution shall promptly report such crime. Sheriff Berry, from your standpoint, what would be really the minimum amount of information that the institution would have to share with you to have complied with report such crime?
We have a report of a rape.
No names?
No name.
No victim?
No
information other than we have a report of a rape on our college campus? That would...
It follows what we do now, Representative Williams, with the instant case we have over at the University of North Georgia as I sit in this chair. We know that happened. They published a Clery Act notice saying that it actually took place. We don't know if it took place or not. Nobody's investigated it. But the UNG reached a conclusion it had taken place. So they have a Clery Act notice which is available online. You can look it up on your phone. But that there's no victim. I don't know. I know the victim is a male.
Thank you. Thank you, Mr. Chairman.
And this would be compliance with that statute.
Chairman Knight.
Thank you. Representative Quick, thank you for working with this. And I go back to something that Chairman Williams had just talked about it, and it goes back to, I think the part of this is preserve the choice of the victim of how they, is it reportable or not. And I know you as a learned attorney, we've got several learned attorneys, on the committee in the room, but, we talk about, or at least in my sort of dialogue, I'd talk about, having the right person to go to that would fit up under the mechanism that is clearly in the bill of confidential, that could keep it confidential. But I've got another part, and I think oftentimes we may overlook other parts of the law, but, at some point, you go to, say, a coach or a professor who's not equipped to do with it, or to deal with it. But what liability or what position may we be putting them up under in law, or the institution as an agent? In other words, let's say it was a serial rapist, and it was something, was concealed and it never got out, and you put a teacher, a professor or somebody like that. I get at, let's preserve the choice, but you've got to steer it back into, where it's confidential to people we know who can deal with it. But if you just go and blurt it out to anybody, and I think that's what this is saying, it's got to be confidential. Is it not? Aren't we putting some other people in jeopardy, or perhaps we're leaving the institution open for liability under litigation?
Let me just hang on.
If say the professor in this case got it but didn't pass it on.
I'm going to let Sheriff Berry say something about that in just a minute, but I appreciate you calling me a learned attorney in this topic. I've learned a lot since Chairman Earhart showed up at my desk that morning, and certainly Chairman Golick has some historical reference about this, and maybe other members that are sitting here, but we have a statute in Title 17 that gives a victim of sexual assault the choice not to cooperate with law enforcement. And if memory serves me, I'll have to go back and check this now, I believe Speaker Ralston signed off on that bill when he wasn't Speaker Ralston, and that it was a bipartisan measure from this body. And so this is another balance that we have to strike in addressing these issues and the special nature of sexual assault. We balance away, perhaps some, on campus at least.
But specifically on my question, though, is, and a lot of times they, I think I've heard from some of the folks who have been in this situation say, don't limit this. What I'm saying is we live in laws, and there's other statutes that, for instance, you just brought up that, hadn't been discussed today. But do we leave open, if it's unlimited in a sense of you can go to somebody not within this confidential list, that can keep the information confidential, that we expose somebody to a liability, we jeopardize somebody's position because they're not trained to deal with this, or they're an agent of the college or the institution, and it may somewhere down the line in some other legal proceeding or other state law, hey, you should have done this. You had a duty to report this. That's where I may be getting off topic, but I want to make sure that we're because obviously there's some liability out there in the world we live in. There could be liability.
Chairman, I would suggest that it's the nature of this legislation that absolves the institution of that liability, because once the report is made to law enforcement, the statute says it's the law enforcement responsibility to conduct the investigation, and then law enforcement has to collect whatever evidence they can, with or without the cooperation of the victim. But at that point, the institution has met its obligation.
Let me find a parallel for you, Chairman Knight. Carrying knives to school, as we all know, is a crime in the state of Georgia. Carrying knives to school. Not allowed to do that. We did, but not allowed to anymore. It's a crime. Principal will call us, say, Johnny has a knife. It fell out of his backpack in the classroom. We're required by law to tell you that happened. Thank you. Appreciate it. You told us it happened. That meets the statutory requirement. It doesn't mean I have to do anything. Now, Johnny reaches into his pocket, pulls out a knife, and tries to cut Joey. Now we've got a whole nother problem. Okay? Now, and this to me is no different than that. There's nothing in this, there's nothing in here that makes me do anything. I can't make the university give me a name. There's nothing, you've given me no power in here that I don't already have or not have. And rightfully so, Mr. Chairman.
Thanks. Okay, next is this you, Chairman Sensler, or is this, okay?
Yes, Mr. Chairman. Sheriff, appreciate you being here. Want to get back to something that was said. I know we've had sort of a dry discussion here. Forgive us. This is not show business. We're just trying to get the facts here. But it was very meaningful to me in some of the earlier testimony today, the sense that if the facts are handed over to law enforcement, there's this sort of, and it was this sort of runaway case that you can't, that a victim can't draw back in. And if that were the fact, that would be very meaningful to me to try to limit that. But what I wanted to hear from you, Sheriff, you were the president of the Sheriff's Association a couple of years ago, correct?
Yes, sir, I was. Thank you.
So in that role, would you say you have a pretty good feel for sheriffs across the state in terms of how they do things? And
yes, sir, I do.
Okay. So I'll speak to you, I guess, in that role, more focused on statewide than just Oconee County. If there were a circumstance where a mandatory reporter were to share, for example, not a burglary case or a aggravated battery case, but a rape case, the sensitive things we're talking about. If that were brought to your department or to another sheriff's department through a mandatory reporter, and the sheriff's department goes to and the victim was identified, and the sheriff's department went to the victim and said, hey, we were told about this. We'd like to talk to you. If after that conversation, the person said, listen, it was a terrible weekend, I don't want to talk about it. Is there any sense that this gets taken out of the hands of the victim and becomes some runaway thing, or is there a sense?
I believe everything Ms. Starling said when she said that somebody put the tape recorder on there and said it's like throwing a football. Once you start, you can't get it back. I forget exactly how she phrased it. I believe that's exactly what happened. I regret that she was told that. Simply not true. We've had rape cases go all the way right before the grand jury when the victim decided to proceed no further. It can be done at any time. Because I regret, and I know. I believe she was told that. I think
it's not the law.
It's not the law. It is not the law. The victim can always withdraw cooperation, and we're not going to proceed without the cooperation of a victim. Why would we?
And Mr. Chairman, I asked the question to the sheriff, and I appreciate you, because we're trying to get legal clarity out of circumstances that are very emotionally complex and fraught with all kinds of issues, and I wanted to get a sense from you as a law enforcement leader in the state. There's not some runaway process that once that if it were invoked by a mandatory reporter, it runs away and can't be stopped by a victim. Although it is a grave concern. I think that's.
Yes, you're right. It could always be stopped. Process can be stopped. Of course it can. Of course the process can be stopped. Now, I see this as an institutional report, not an individual report. And they're two different things. It's just like the Clery Act notice that's posted online from UNG yesterday, or today, whenever they did it. They have the limited amount of time to do it. But it is no more than that to me. Yes, we have a report of a rape. Does the victim want to cooperate? No. Okay. If she changes her mind, these are the people this is what I'd like for her to know.
In the what's the statute of limitation for rape in Georgia?
Is it 4-7? I think it's 7. Danny Porter. Yeah, I think we need Danny Porter here. I don't practice law.
Ask that question to him when he gets up there.
But it's a circumstance where if someone was
significant,
emotionally just fractured, they could come back at some point within a couple months.
And as you know, this legislative body's instructed me and every sheriff and peace officer in the state of Georgia that we're required to keep that evidence and send it to the crime lab, even if the victim doesn't want to prosecute.
So it's not like they're waiving some right to bring a case 2 years down the road. The statute doesn't run for a few years.
A significant amount of time. Yes.
Okay. Members of the committee, just an announcement. We've got another question by Chairman Williams. We're now 2.5 hours into this. I'm trying to be as courteous to the members of the public and to the members of this committee as I can. These hearings tend to go long, and I'm appreciative of the amount of good information that we're getting. We have one more for and one more against still to testify. We have one more question of Representative Quick and the sheriff here. What I'm going to ask is, just taking the temperature of the members of the committee, I want you to be able to be present for the vote that you spent so much time listening to the testimony. I think Representative Golick, Chairman Golick needs to go as well. But if how much more time do you have? 10 minutes or so? So what I'm going to ask is that we expedite the remaining two testimonies. I don't want to truncate that. There'll be other opportunities as we go. I'm going to let Chairman has another question for you, and Ms. Robinson, and did I see District Attorney Porter? Are you back there? If it's not too much of an imposition to move your testimony along just a little bit on that, I don't want to make it two, but this is two and a half hours is a long committee hearing, and we're trying to hear from everybody, I think. So, Chairman.
Thank you, Mr. Chairman. Chair Bear, are there any aggravating circumstances relative to a sexual assault that would require you, regardless of the victim's wishes, to initiate an investigation? Use of a deadly weapon, anything of that nature that would trigger you?
Short of a murder, no.
Okay. Thank you.
All right. Thank you very much. Thank you, Sheriff. Thank you for other members of your staff that took the time. Next up is Ms. Robinson, and then you, District Attorney Porter. And thank you for sitting through a significant amount of time. So
yes, thank you.
Please proceed.
Thank you, Chairman. Thank you for the opportunity to speak and for your efforts to address the important issue of campus sexual assault in Georgia. And I do think that everyone in this room has the same goals. We want a non-biased and fair process, and we want good policy for dealing with this very important problem. While we agree on goals, we urge caution in moving forward with House Bill 51 at this time. We believe that the mandatory reporting provisions in the bill will have harmful, unintended consequences. It will chill reporting of sexual assault on campus overall and lead to fewer students seeking services and help. Sexual assault is a crime that has a unique impact on victims. It cannot be compared to all other types of felony crimes. While this may seem counterintuitive to you, survivors, as you have heard, sometimes choose not to report to the police right away. They may have fear of retaliation from the accused, who is often someone they know very well and see often. They may have an unwillingness to participate in a time-intensive and sometimes re-traumatizing criminal process that can take years. And they may have a recognition that very few cases ever reach final judgment in court for sexual assault. It is universal practice in this state and in this country to allow sexual assault victims to choose when they report to the police. Limiting their options or taking this choice away from them after a violent assault is widely understood to be an ineffective approach. Adult sexual assault victims in Georgia can determine when to report to law enforcement. It would be unprecedented to take that ability away from adults who happen to be college students. And I do want to say that the testimony that we just heard, we have got to get clarity on that. If this is talking about non-identifying data like required by the Clery Act, I don't see that in this bill. So we must get clarity on that. And actually, the chairman himself opened the hearing by saying, you cannot expect to report to university police or another law enforcement agency without expecting an investigation. So we must understand what is the motivation and the actual way this will work in practice. And also, we know that victims can be subpoenaed if they choose not to cooperate. It may not be best practice. We know it's not best practice, but it can happen. Students who are victims of sexual assault need access to individuals on campus to talk through all of their options for services, counseling, and support, whether or not they choose to report to law enforcement. The new version of this bill does carve out that certain list of privileged communications that exists in state law, but it doesn't include the staff of a women's resource center, for example, the most obvious place that a student may choose to go. There are social workers who aren't licensed social workers. And to expect a student to understand the law, I had to look it up when I heard the title code section and see who's privileged. I don't know. I know lawyers who don't know. And so the end result will be a chilling effect. Students will feel they do not have the ability to talk to people confidentially, and then you end up with fewer reports, which will ultimately end up to fewer prosecutions, because if you don't talk to anybody, you're certainly never getting your case onto law enforcement. Also, it's very important to understand that even if you make it very clear to students that there's a counselor here that you can go to, if they want to start their disciplinary hearing, which is allowed in this bill, they have to tell whoever runs the student code of conduct process. And that would be an employee of the university, and it would trigger the automatic police report. So there would be no way for a student to access the interim protective measures, which we greatly appreciate that you've all identified as being important. There'd be no way to access those without reporting to police. So you're basically, again, mandating police reporting for victims, which is unprecedented. In practice, many victims will not seek or receive help at all under House Bill 51. I also want to clarify that there are two things that this bill does. One is mandatory reporting. The second thing that it does is it requires sexual assault cases to all go through the regular student code of conduct hearings. So all the testimony that you heard from the attorney earlier about what's wrong with these hearings, that is not addressed with this bill. In fact, the Board of Regents policies for sexual assault hearings that are in place now, as Jessica mentioned, they've only been in place for one semester. They have a higher standard and more due process in them currently than the student code of conduct hearings. So again, we've got to get clarity. You know, what are we trying to achieve here? If we're concerned about the process, which everyone here I think is, then let's improve the administrative process, and let's look at the brand new policies and see what do we need to do next. And we want to include advocates and survivors in that conversation, because they know, they've had the experience, they know what needs to improve, as well as the accused. But let's not get confused and think that passing House Bill 51 addresses all the concerns that you heard the defense attorney speak to earlier, because it does not touch that. And I'm open for any questions.
Chairman,
Ms. Robinson, I appreciate your comments. You still go back to a mandatory reporting, and I see where there is mandatory reporting outside of the confidential, the set out of the confidential people. But I want to make sure, obviously people walked in here today and they had a prior version of the bill and were not privy to the bill, this bill that had been worked on so much by the chairman and representative. Your concerns or your comments are almost as if this bill did not happen or there are changes. I want to make sure that you're clear on that, or that we're clear on that. Your comments are as if it were for the original bill and not this one.
Both the original bill and the substitute bill require mandatory reporting by employees. The substitute then does reference what already exists in state code, which says that there are privileged communications between like an accountant and an attorney, psychiatrist, that list of professionals. So with that carve out though, what we're saying is there are still many people that you would naturally go to on your campus that would not fit into those limited
Okay.
list.
One follow-up question, Mr. Chairman, if I may.
go ahead.
And I heard you say that, that's great as far as some of the things that had happened here, but you also said that, what about the interim? How do we go into an interim, I guess disciplinary or the separation? You still go back to the heart of, I think, why we're here is that you're making a major accusation, and I'm not saying, probably in a lot of times it is very true, but it is a major accusation. You can't have an accusation and accuse somebody of something and then expect to, stay quiet. I mean, if you're accusing somebody and you're going through this policy that's on the university system as it is, how can you have both? And how can you have that due process? So if somebody's accusing somebody of something as a crime, which is heinous. I mean, everybody in this room hates to even hear of this. how can you have both? And I think that's what we're trying to.
Yeah.
There's a problem, and you can't. There's sometimes in life you can't have it both ways.
So you have to have both because of federal law. Campuses must have grievance procedures on campus for dealing with sexual assault. That is federal law, not the letter that you're talking about. That's law. And we will have both in the current bill in front of you, only it'll go through the regular student code of conduct process, which actually has a few steps that are maybe not as much due process as the current sexual assault hearing process has. So I hear your question, and I'm not dismissing it, but this bill does not do anything about that, and you cannot get rid of the on-campus grievance procedure for sexual assault. That is a violation of federal law.
Well,
and they also serve two purposes. As you've heard from everyone who's spoken today, the on-campus procedure is not a criminal procedure. It has nothing, it is not supposed to be. It is about giving you the right to continue your education.
But we also heard testimony of how this procedure has literally ruined the lives of, we know one person, if not others that we're unaware of out there. And again, we're trying to deal with an issue that solves both and gives, I'm not sure how you can have both in this and have due process and fairness to an accuser, which is the basis of our Constitution, our federal laws, and our state laws, and of such a heinous accusation, a crime. I don't know how you can do it and have it both ways. And I say that seriously. I'm sitting here trying to understand this and trying to figure a way out, but I don't see how you do both.
Again, I would just say that the on-campus disciplinary proceeding is not a criminal justice proceeding, never has been. It is required. It is required in every campus in the country. And again, that's something we are very happy to work with you all to look at these new rules that were just implemented and say, what do we need to do next? But I don't see how any provision in this bill actually deals with that concern that you're putting forward.
Okay. Thank you very much for your testimony. Okay, we're down to last. I know you had to spend time in the Senate this afternoon. I apologize for that. But thank you for taking the time.
Hopefully this will be less confrontational. My name is Danny Porter. I'm the district attorney for the Gwinnett Judicial Circuit. I'm also the legislative liaison for the Prosecuting Attorney's Council. I want to answer Representative Setzler's question. The statute of limitations for rape in this state is 15 years. There are certain sexual offenses where if DNA is used to establish the identity of the perpetrator, then prosecution can be initiated at any time. That includes aggravated sodomy, aggravated child molestation, and certain other sexual offenses. I'm really here for a very limited purpose, and that is as the end consumer of whatever investigation is conducted, whether it's conducted by the college or whether it's conducted by a layperson or whether it's conducted by police officers and trained post-certified personnel. And it is, in my circuit, a fairly common situation. But on the other hand, I'm very lucky. I have Gwinnett College that has a highly trained post-certified police department. They have an active reporting program, and we have prosecuted sexual assault cases on that campus successfully. And I'm just here to say that, in general, I can speak for the prosecutors of the state when we say we would rather have assault allegations that are turned over to us for prosecution investigated by trained police officers than we would by school administrators, because school administrators are not as careful about the niceties of constitutional rights, search and seizure provisions, and now I don't have an opinion, and I don't think the district attorneys have an opinion as to whether or not there should be, because we understand that in a case Where a victim chooses not to go forward, that is almost a final decision. I think in 35 years of prosecution, to be honest with you, I can't think of a single case, even to the point where we were days before trial, where we were in a situation where a victim told us, we just cannot do this. We've gone this far, but we cannot do this. Now, I've worked some pretty amazing deals, but I've never forced a victim onto the witness stand to testify. And I can't say that for every prosecutor. I can say that for me. So there is a way. It's just not, I don't see how it's conceptually possible to force a sexual assault victim onto the stand and win a successful, convincing case in front of a jury. So, but getting back to what I was asked to talk about is I would much rather have these cases investigated by law enforcement than have to try and piece a case together that was done by non-law enforcement. And I'll be happy to answer any questions to my limited expertise.
Any questions for Mr. Porter? Mr. Porter, thanks for sticking around. We appreciate that. I don't see any questions. I think we're finally getting to that point.
They all are tireder than I am, so thank you.
So, okay, members of the committee, we've had a fairly significant public hearing on this issue. I think we are charged with many times. I think it was Representative Fleming that talked about a tenuous balance between a tenuous balance between public safety in general, campus safety in general, the rights of the victim. This is a serious crime and serious issues. So I obviously, since I brought this legislation and have worked through it with Representative Quick and others, I think this strikes that balance. And I'm bringing that to you for a discussion and a vote. I think we've been here a while, so I'll entertain a motion, and then we can have some other discussion. There's a motion and a second to pass. Is there further discussion? Chairman Sessler.
Mr. Chairman, as it pleases the chair, I would be interested to hear the chair's posture on proposed amendments, whether it's at this point or it's something, perhaps a substitute between now and full committee. I had prepared a Sessler Amendment 1 that dealt with rules of evidence prevailing in judicial the hearings be subject to rules of evidence consistent with judicial hearings, and also that any violation be proven by clear and convincing evidence that would lead to a punitive administrative action. I would leave it to the chair's discretion to whether you would entertain the amendment now or in a substitute, but there's some things that I think we heard today that persuaded me that we do need to have a evidentiary standard, even as Mr. Porter said. Evidence that's collected by university people could potentially even spoil a criminal investigation down the road if charges were brought. That hearsay evidence is presented in these hearings. It's really just, I think it's been a parade of terribles in terms of the way these hearings play out. And I think in statute, as the substitute's drawn today, it's not clear how that is being prescribed by the legislature. So I've drafted an amendment, or if I just wanted to ask the chair how he'd ask me to
Let me
proceed.
ask you this, Chairman Sessler. What I'd like to do, you gave me the courtesy of looking at this before the meeting, and I'm very appreciative. What I'd like to do, because of the way we've tried to balance this with the stakeholders on every side of this issue, with Representative Quick and the Board of Regents who work collaboratively, and even the advocates against the bill, we've talked about certain things with respect to that. This is the beginning of the process. This is a subcommittee hearing and vote. There'll be a full committee. There'll be, if it continues to succeed, there will be action on the floor of the House. It'll have to go through Rules Committee. There's a lot of places. I'd like to sit down and vet this amendment and see where it fits, how it fits, talk to the legal counsel with the Board of Regents, see if there are any issues with that. If you'll do me that courtesy, I'll be more than happy to continue to entertain as we walk through the process.
I'd be happy to, Mr. Chairman. I would say, having heard the testimony today, there's a few things that I think would even in terms of providing some structure to the hearing process, not contemplated in this amendment, we could even add to this. So I appreciate your consideration.
Okay. The next is Chairman Golick.
Thank you, Mr. Chairman. In the same spirit of the Chairman Sessler expressed, I agree on the evidentiary standard. I think we should also look at uniformity is a word that really stuck in my mind as we went forward. I think, though, that does have to be reviewed in the context of the university system's new policy that I know witnesses referenced that's only been in effect for a certain period of time. So I think we do need to take a look at that from a uniformity standpoint. Just from a structural standpoint, I did, and the sheriff's testimony was very helpful in illuminating on a couple of things.
Me too.
Line 26, when it says the post-secondary institution shall promptly report such crime to the campus law enforcement agency or other appropriate law enforcement agency, I don't think it's crystal clear, and I think one of our witnesses alluded to this as well, may have. I don't think it's crystal clear about what does that actually mean. So, shall promptly report such crime. Is that just the occurrence of a crime? Is it the crime with certain identifying information? What is that? I could see two judges coming up with three opinions on that.
I can see some clarity being added to that. And I'll
So
work with you on that as
I
well.
think that's something that we may need to look at, and as the chair says, as
You can
the process
anticipate
goes forward.
a substitute for the
Thank you.
full committee on that. All right. I don't see any further questions from the committee. We have a motion and a second. All those in favor signify by saying aye. Aye. Opposed? Motion passes. It moves to the full committee. Thank you, everyone.
Thank you, Mr. Chairman.
Thanks for sticking in.
Good job.
Thank you. Hey, both of those we can add to the substitute. I'd rather.